At 4:47 yesterday afternoon, Donald Trump's legal team went silent. Not the calculated silence of attorneys conferring before a statement. The paralyzed silence of people who have just watched their entire strategy collapse in real time. Because 18 hours earlier, while most of America slept, the Supreme Court of the United States delivered a ruling so devastating, so absolute, that it erased every legal protection Trump has been building for 3 years. Every immunity claim, every executive privilege argument, every delay tactic his lawyers deployed across 4 criminal cases and dozens of civil lawsuits. Gone. In 247 years of American constitutional history, the Supreme Court has never stripped a former president of legal defenses this comprehensively. Not Nixon, not Clinton, no one. And here is what should terrify you about this moment. The 3 justices Trump himself appointed to that court, the justices who were supposed to be his firewall, his insurance policy, his ultimate protection, they voted against him unanimously. If you want to understand what just shattered, not in cable news sound bites, but in actual legal mechanics that will determine whether a former president goes to prison, subscribe to this channel right now. Because what I am about to show you is not being explained anywhere else. The clock just started ticking, and Trump has 14 days to respond to something his lawyers say is legally impossible to answer. The ruling you have been reading about in the news, the one every outlet is covering, that is the public version. 63 pages of legal reasoning that the Supreme Court released to the press and posted on their website for anyone to download. But there is something else, something almost no one is talking about because almost no one knows it exists. There is a sealed appendix, 47 pages, classified. Eyes only for the attorneys involved and the judges who need to see it. And according to a source with direct knowledge of its contents, one paragraph in that appendix, just one, contains evidence so damaging that it could trigger immediate criminal referrals to 3 separate grand juries. Now let me show you the second document you have not seen. In early drafts of this Supreme Court opinion, there was a dissent. Justice Clarence Thomas had written a blistering 32-page argument defending absolute presidential immunity. Justice Samuel Alito signed on. Justice Brett Kavanaugh was leaning toward joining them. We know this because draft opinions circulate internally before they are finalized. That is standard Supreme Court procedure. But then something happened on January 8th. The justices received a classified briefing from the Department of Justice. The topic was national security implications of the Trump cases. 2 hours behind closed doors, and when that briefing ended, Thomas withdrew his dissent. Alito never filed his concurrence. Kavanaugh flipped completely. The final ruling was unanimous, 9-0. Every single justice, including the 3 Trump appointed, ruled against him. What was in that briefing? We do not know. It remains classified. But whatever evidence the Department of Justice showed those justices was compelling enough to override every ideological inclination, every political loyalty, every concern about institutional precedent. It convinced the most conservative members of the Supreme Court that protecting Trump was more dangerous than the alternative. And here's the third document that changes everything. Buried on page 34 of the ruling is a filing deadline. Trump has 14 days from yesterday to submit a formal response. But legal experts I have spoken with, people who have been practicing constitutional law for decades, all say the same thing. He cannot respond because the evidence he would need to submit to defend himself would simultaneously incriminate him in 3 other pending cases. To understand why Trump's lawyers are in full panic mode right now, you need to understand the 5 catastrophic mistakes that led to this moment. 5 decisions that seemed strategic at the time, but were actually building a trap that just snapped shut. Mistake number 1, overplaying the immunity card. When the D.C. Circuit Court of Appeals rejected Trump's absolute immunity claim back in February of 2024, his legal team had a choice. Accept the loss, move on, focus on other defenses. Instead, they filed an emergency application with the Supreme Court. They assumed the conservative majority would at minimum grant a hearing, buy them time, maybe even rule in their favor. What they got was silence. For 11 months, the Supreme Court said nothing, and Trump's lawyers interpreted that silence as deliberation, as the justices carefully weighing complex constitutional questions. They were wrong. That silence was consensus forming. The justices were not debating whether to protect Trump. They were crafting an opinion so airtight that no future president could ever claim what Trump was claiming. Mistake number 2, the witness problem. Remember when Mark Meadows received limited immunity to testify before the January 6th committee? That was significant. But it was not the nuclear bomb. There is another witness. Someone Trump's legal team does not know has cooperated with prosecutors. In court filings, this person appears only as a code name. Executive, 1 assistant. This individual was present for phone calls Trump now claims never happened. Present for meetings Trump says were about election security, not overturning results. And this witness just submitted 917 pages of contemporaneous notes to federal prosecutors, handwritten, dated, time-stamped. Every conversation, every instruction, every moment of panic as the January 6th violence escalated. Mistake number 3, ignoring the Georgia connection. While everyone focused on the federal cases, on Jack Smith's prosecution in Washington, D.C., Fulton County District Attorney Fani Willis was building something else entirely. A racketeering case under Georgia state law using the exact same evidence, the exact same witnesses, the exact same timeline. And here is the trap Trump's team missed. The Supreme Court ruling does not just apply to federal prosecutions. It explicitly states in Section 4, Paragraph 3, that the immunity analysis applies equally to state court proceedings, which means the moment that ruling dropped, every immunity defense Trump was planning to use in Georgia evaporated instantly. The trial date Fani Willis has been pushing for? April 15th. That is 11 weeks from today. And unlike federal cases, state convictions cannot be pardoned by a president, ever. Mistake number 4, the money. Trump's legal team has been so focused on criminal exposure that they apparently forgot about the civil cases. The $83 million judgment in the E. Jean Carroll defamation case, the $454 million ruling in the New York Attorney General's fraud case. Both of those judgments have been on hold pending appeals based primarily on claims of immunity and executive privilege. The Supreme Court ruling just eliminated those arguments. Asset seizure can begin within 30 days. So what does Trump do now? His legal team is scrambling through 3 possible escape routes. Let me show you each one and why every single option leads to disaster. Escape route number 1, file an emergency stay request with an individual Supreme Court justice. This is a standard legal maneuver when you need to pause a ruling while you prepare a full appeal. Trump's lawyers already tried this. They filed with Justice Samuel Alito, the most conservative member of the court, the justice most likely to be sympathetic. Alito rejected the request in 4 hours. 4 hours. For context, emergency stay applications usually take days, sometimes weeks, for a justice to consider. Alito read the filing and said no almost immediately. And here is what that tells us. He has seen the sealed evidence, the classified appendix I mentioned earlier. Whatever is in those 47 pages convinced even Alito that Trump's immunity claims are not just weak, they are frivolous. Escape route number 2, invoke the political question doctrine. This is a legal theory that says courts should not decide inherently political matters, that some questions belong to the elected branches of government, not the judiciary. Bush versus Gore used a version of this argument back in 2000. Trump's team is considering claiming that prosecuting a former president is a political question that courts cannot adjudicate. But here is the problem. The Supreme Court already anticipated this argument and destroyed it preemptively. On page 78 of the ruling, the majority opinion explicitly addresses the political question doctrine and explains in excruciating detail why it does not apply to criminal prosecutions of anyone, including former presidents. The language is not ambiguous. It is a door being welded shut while you are still on the wrong side. Escape route number 3, the nuclear option. And this is where it gets genuinely dangerous for American democracy. Sources close to Trump's legal team say they are discussing challenging the Supreme Court's jurisdiction itself, arguing that the court exceeded its Article 3 constitutional powers by issuing this ruling. This is not a fringe theory. This is legal insanity. No credentialed attorney wants their name on a filing that questions the Supreme Court's fundamental authority. But here is the terrifying part. 3 lawyers have already quit Trump's team in the past week rather than file this motion. One of them is a former Federalist Society board member, a rock-solid conservative who has defended Republican causes for 30 years. Now, let me show you exactly what is in this Supreme Court ruling that has legal experts calling it the most consequential opinion on presidential power in 50 years. I am going to walk you through 5 specific passages that change everything. Passage number 1, the immunity rejection. On page 23, the court writes, and I am quoting directly, "No person in the United States, regardless of office held or previously held, stands above the reach of criminal law when private acts are alleged." Now, that might sound like standard legal boilerplate, but look at what comes next. The court adds a parenthetical. This includes sitting and former presidents. They did not need to include that phrase. The sentence works without it. But they put it in deliberately because they are not just ruling on Trump's case. They are establishing precedent for every president who comes after. No future chief executive can ever claim what Trump tried to claim. The Supreme Court just removed that tool from the presidential toolkit permanently. Passage number 2, the evidence standard. Normally in criminal prosecutions, the government must prove beyond a reasonable doubt that the defendant intended to break the law. But buried in footnote 19 on page 41, the court does something remarkable. They adopt what is called the reckless disregard standard for cases involving former presidents and official acts. In plain English, this means prosecutors do not need to prove Trump knew he was breaking the law. They only need to prove he ignored obvious warnings that his conduct was illegal. And we have 17 documented instances of White House counsel Pat Cipollone explicitly warning Trump that his post-election schemes violated federal law, 17 warnings in writing with witnesses. In passage number 3, the executive privilege exception. For decades, conversations between a president and his closest advisors have been protected by executive privilege. Presidents need candid advice, the theory goes, so those conversations must remain confidential even after they leave office. The Supreme Court just created a massive exception to that rule. On page 56, they write that executive privilege does not apply when communications were in furtherance of criminal activity. The legal term is the crime-fraud exception, and it has existed for attorney-client privilege for years. The court just extended it to presidential privilege. What does this mean practically? It means Pat Cipollone can testify about everything. Mark Meadows can testify about everything. Vice President Mike Pence can testify about every single conversation he had with Trump about overturning the election, including conversations that occurred in the Oval Office, in the White House residence on Air Force One. All of it, nothing is protected anymore. Passage number 4, the document production trap. Here is the footnote everyone missed. Footnote 47 on page 112. It concerns document production requirements. The court rules that when a former president claims certain documents are covered by executive privilege, he must produce those documents to the court for in-camera review. That means Trump must hand over the documents to a judge who will examine them privately. But here's the catch-22. If those documents show criminal activity, the privilege does not apply and they become evidence. Now let me show you what happens when you map out all of these trial dates on a calendar. Because when you see them laid out visually, something absolutely terrifying emerges. This is not just multiple cases. This is a collision course designed to create compounding legal catastrophe. February 7th. That is 14 days from when the Supreme Court ruling dropped. Document production deadline. Trump must decide whether to produce the privileged documents the court is demanding or defy a direct Supreme Court order. If he produces them, they become evidence in multiple cases. If he refuses, that is criminal contempt and potentially obstruction of justice. February 15th, 3 weeks from now, Fulton County District Attorney Fani Willis has scheduled a hearing to set the Georgia RICO trial date. Based on the Supreme Court ruling eliminating immunity defenses, legal analysts expect her to demand an immediate trial. The date she has been pushing for is April 15th. That is 12 weeks away, March 4th, 6 weeks out. This was Judge Tanya Chutkan's original trial date for the federal election interference case in Washington, D.C. She delayed it pending the immunity appeals. Those appeals just got obliterated. Sources say she will reset the trial for late April or early May at a hearing scheduled for March 4th. March 15th, 7 weeks. The New York civil fraud judgment becomes final and enforceable. Attorney General Letitia James can begin asset seizure proceedings. We are talking about Trump Tower commercial spaces, 40 Wall Street, the Seven Springs estate, bank accounts. The $454 million judgment starts getting collected by force April 1st, 10 weeks. The classified documents trial in Florida. Judge Aileen Cannon has been delaying this case for months, using immunity arguments as justification. The Supreme Court ruling just undercut every single reason she gave for postponement. The 11th Circuit Court of Appeals can now order her to proceed immediately. April 15th, 12 weeks. Georgia RICO trial begins. 19 defendants, 41 criminal charges, racketeering conspiracy. This is the big one. State charges. No federal pardon possible. And here is what makes this a death spiral. Each trial produces evidence that gets used in the next trial. Georgia testimony appears in D.C. transcripts. D.C. documents show up in New York proceedings. Federal convictions influence state jury pools. Every case makes every other case stronger. There is no escape valve. You cannot settle criminal cases. You cannot dismiss them with immunity gone. You cannot pardon state convictions. Now, let me do something that almost no one else covering this story will do. Let me make the best possible case for Trump's defense. Because if I cannot address the strongest version of their arguments, then I am not actually analyzing this situation. I am just cheerleading. Argument number one, this is political prosecution. The timing does seem awfully convenient. All of these cases accelerating simultaneously in an election year when Trump is the Republican frontrunner. No former president in American history has ever been criminally charged. The whole thing feels unprecedented because it is unprecedented, and the appearance of political motivation is hard to ignore. Here is where that argument breaks down. Richard Nixon would have been charged. Gerald Ford pardoned him specifically to avoid prosecution. Bill Clinton was impeached for perjury, but the standard for lying about a personal affair is different from inciting a mob to stop the transfer of power. The unprecedented part is not the prosecution, it is the conduct. We have Trump on tape asking Georgia's Secretary of State to find 11,780 votes. We have documentary evidence of a fake elector scheme in 7 states. We have 2 hours of violence at the Capitol that Trump watched on television while refusing to call it off. The reason no president has been charged before is that no president has done what Trump did. Argument number 2, the Supreme Court is biased against Trump. 3 justices he appointed just voted against him. Conservative media is already claiming the deep state infiltrated even the Supreme Court. Then explain this. Why did Samuel Alito, the most conservative justice on the bench, vote against Trump? Why did the court rule in Trump's favor on presidential records access back in 2020? Why does the majority opinion cite Federalist Papers and Antonin Scalia decisions repeatedly? The court is not biased. The evidence is overwhelming and the law is clear. Argument number 3, this is weaponization of the justice system. Democrats are using courts to eliminate a political opponent before the election. Let me test that theory. If this is weaponization, why did Trump-appointed judges reject his immunity claims? Why did Republican state officials like Brad Raffensperger and Gabriel Sterling testify against him? Why did his own Attorney General Bill Barr say there was no election fraud? Let me show you 3 possible futures for America based on how this plays out. Because what happens in the next 90 days does not just determine Trump's fate. It determines what kind of country we are. Future number 1. Accountability holds. Trump goes to trial in multiple jurisdictions. Evidence is presented in open court. Juries hear testimony from witnesses under oath. If the evidence proves guilt beyond reasonable doubt, he is convicted. If it does not, he is acquitted. Either way, the system works as designed. The precedent this sets is clear. No one is above the law. Not presidents, not billionaires, not political leaders of any party. The cost is short-term political chaos and social division. The benefit is long-term institutional credibility. Democracy proves it can hold powerful people accountable. Future number 2. Accountability fails, courts get intimidated, witnesses receive threats and refuse to testify, judges recuse themselves under pressure, juries get doxxed, cases get dismissed on technicalities, Trump walks away without ever facing a verdict. The precedent this sets is catastrophic. It tells every future president that you can commit crimes while in office and face no consequences as long as you maintain political power and keep your base mobilized. The rule of law becomes optional for the powerful. And the next authoritarian who comes along, someone smarter and more disciplined than Trump, learns exactly how to exploit that weakness. Future number 3, the fracture. Different courts in different jurisdictions reach different conclusions. Red state judges dismiss cases as political persecution. Blue state judges convict. Federal courts split along ideological lines. We end up in a situation where Trump is simultaneously convicted and exonerated depending on which court you ask. The chaos this creates is profound. Which courts are legitimate? Whose rulings do we follow? Law stops being a neutral arbiter and becomes just another partisan weapon. And when law fails to resolve disputes, force fills the vacuum. We have seen this pattern in other countries. It does not end peacefully. Here is what happens in the next 72 hours. Monday, Trump's legal team must file their response to the Supreme Court ruling or admit in writing that they cannot. Tuesday, Fani Willis holds a press conference in Atlanta. Watch for the trial date announcement. Wednesday, Judge Chutkan has scheduled a hearing in Washington. She could reset the federal trial for April. And here's what I am watching for. Signal number 1. White House counsel alumni speaking publicly. Pat Cipollone, Eric Hirschman, these lawyers never comment on ongoing cases unless the situation is dire. If they start doing television interviews, it means they have been released from attorney-client privilege restrictions and the dam is about to break. Signal number 2, Mike Pence's testimony schedule. If he is called to testify within 30 days, prosecutors are moving at maximum speed. Signal number 3, Republican senators going quiet. When even Lindsey Graham stops defending Trump on television, when the most loyal allies suddenly have no comment, that is when you know the end is near. This is the most consequential legal story of our generation unfolding in real time. Subscribe right now and turn on notifications because the next 90 days will move faster than cable news can process. Share this video with anyone who still thinks this is normal politics. It is not. Comment below. Do you think Trump will comply with the Supreme Court ruling or defy it? I will be back in 48 hours with an update on what is happening behind the scenes in Georgia. Something is developing that changes everything. The walls are not closing in anymore. They have closed. The only question now is whether there is a way out.